in 2016 actually came out of Chicago. It's the first case listed on your side, Lake Michigan Beach Potawatomi Resort. That was a Michigan corporation, so it was governed by Michigan law. And in that case, as a condition to a forbearance agreement that was entered into just a few months prior to bankruptcy, the debtor modified its operating agreement to grant its lender blocking rights in its capacity as a special member of the LLC, and that blocking right included the right to prevent a bankruptcy filing. And so when this Michigan LLC went into bankruptcy, they couldn't get the lender or special member's consent to the bankruptcy filing, so they filed the company, and the lender filed a motion to dismiss, saying the filing was not properly authorized. Ultimately, in that case, and in looking at the operating agreement, Michigan corporate law, the bankruptcy court in that case denied the lender's motion to dismiss and said that based upon Michigan law, the filing was properly authorized. And the reasoning of the judge in that case revolved around that special member and what the special member had to consider when deciding whether the member could only properly exercise that consent right if it considered the interests of all the other constituents involved. In the Intervention Energy Holdings case, which came fairly soon after that, that was out of Delaware, where there's obviously a lot of bankruptcy filings, and it involved a Delaware corporate entity, which is also where most corporate entities are formed. So it was a case that was of significance. In that case, it was similar facts to the Chicago case, where a lender was granted some rights under an operating agreement to be able to block a bankruptcy filing close in time to the bankruptcy filing. And ultimately, when the court looked at that situation, because again, the company filed, couldn't get the lender who held some membership interest, couldn't get the lender's consent to the filing, lender filed a motion to dismiss, and the bankruptcy court again denied that motion to dismiss and took the position that the member, which also was the lender, could not exercise that blocking right because it was a violation of federal public policy, and the public policy was the right to file for bankruptcy. The bankruptcy court, I will say the Delaware Bankruptcy Court was very careful to say that he was not giving any opinion on whether or not certain blocking rights and certain fiduciary rights and whether those were contracted away were enforceable or not based upon Delaware corporate law. He would leave that to the chancery courts to decide. And then subsequently, there were 3 additional cases that have come out in 2017 and 2018 on these issues. Lexington Hospitality Group was one of the first cases that really dealt with a lender that got its equity interest at the point in time that it extended the loan. So the lender didn't acquire those membership interests in exchange for a forbearance agreement. And ultimately, again, the lender blocked the ability for the company to file for bankruptcy, and bankruptcy court again said that was not enforceable based upon the public policy interest and followed the judge's decision from Delaware on Intervention Energy Holdings. And then Franchise Services of North America, which is an important case because it's at the Fifth Circuit level, so it's the only circuit court decision on this, dealt with an equity holder. So again, unique from the other 3 cases, that was a situation where a preferred stockholder in a corporate entity had to consent or not to a bankruptcy filing. It did not give its consent to the bankruptcy filing. And in that case, the Fifth Circuit said that was an enforceable consent right, and therefore the bankruptcy filing was not properly authorized. So that was one of the first cases. It's at the circuit court level that did allow, but again, for an equity holder, did recognize and allow that equity holder to block a bankruptcy filing. And then finally, just to mention, it's a more recent case coming out of the bankruptcy court in Pennsylvania, also again, dealing with these consent rights and found that the consent right to bankruptcy filing was enforceable. I will say that case was most similar to the Fifth Circuit case, where you again had equity holders who were trying to exercise their rights in their capacity as an equity holder to block it for the percentage ownership, but the bankruptcy court ultimately allowed enforcement and said the filing was not properly authorized. So the takeaway on that is really just making sure you understand your operating agreement. If you have a lender holding blocking rights, maybe that's not going to be enforceable. If you have an equity holder holding those blocking rights, it may actually be enforceable. And then moving on, I'll just mention very briefly, there's other unique structures that come up in the hospitality space. Lombard Public Facilities Corporation, which is the case I was involved in earlier this year, was actually a nonprofit entity that owned a Westin hotel. Seems weird, but that's what they owned. It was a public facilities corporation that was formed by the village of Lombard specifically to go acquire land and build this Westin argument, and ultimately that case proceeded and the restructuring was implemented. And so once you get the entity that owns the hotel into bankruptcy, I'm going to touch quickly on a few different issues that are important to be focused on, get stabilized early on in the case. And the first is really understanding who's running the business. So you need to figure out whether or not the entity that's in bankruptcy is responsible for operating that business, or are they really just a passive owner. I'm going to use the LPFC, Lombard Public Facilities Corp, as an example here, where we had a passive owner. And so that passive owner owned the land, owned the building, but that was pretty much it. It then entered into a contract with Westin, or now Marriott, to basically operate that hotel. You need to carefully analyze that relationship for any hotel when you're getting ready to put the entity into bankruptcy, and understand what the hotel manager is doing versus what the owner, who will be the debtor, can actually do. In our case, the Westin basically employed the employees, was the entity entering into contracts for services and goods at the hotel. They would receive the money and then pay the vendors. They were extending preferred vendor contracts to the hotel. They were providing the marketing support. You know, they were doing everything at the hotel and had complete control over those hotel operations, and really complete control over the cash, as the cash was coming in and flowing back to the owner of the hotel and the land. And so with all of those contractual relationships running through Westin, with Westin having access to the cash to be able to pay the expenses for the hotel, with Westin having those vendor relationships, they were obviously a critical, very, very important creditor in the Lombard Public Facilities Corporation's case, because without Westin being happy and continuing to operate and perform under that hotel management agreement, this hotel could not operate. And so that will be one of the first critical issues. It will be how you keep ultimately your flag, that hotel manager, in place at the beginning of your bankruptcy case, making sure the operations are stable, they'll continue performing in the normal course, and making sure, you know, assuming you want to keep them in place, that you can keep them in place. If we can just move to the next slide, in the Lombard Public Facilities Corporation case, what we ended up doing is we actually did what we called a provisional assumption. You can go maybe back a slide. A provisional assumption of the agreement early on in the case, and agreed with Westin that we would assume the agreement in order to encourage them to continue doing business with them. And we reached different agreements as to how the rejection damages claims and the ability to reject would be dealt with on a go-forward basis in that case. So we came up with a creative solution to make sure Westin would continue to do business with us, but still left open the opportunity to reject that agreement if we needed to. And if ultimately we wanted to reject the agreement, we would have had to replace the flag and change to somebody other than Westin. So you would be going and moving to a new hotel operator. If we can go to the next slide. Just a couple of comments on what the key components you will see in a hotel management agreement are. Is number one, the fee. You need to figure out how they get paid. Usually it's a percentage fee, so it's going to be a percentage of the revenue. In the LPFC case, we actually had a fixed fee, which was driven by the fact that it was a nonprofit entity with tax-exempt bond financing, and under the older tax regulations, the management fee had to be fixed. As part of the restructuring, based upon some changes to the tax code, we were then able to flip that to a percentage fee, so that you have, again, in our case, Westin, the hotel manager, then becomes a little more vested and tied to the performance and success of the hotel if they're being paid a percentage of revenue. The other things you'll see in a hotel management agreement, quality standards all over the place. Is it a 5-star hotel? Is it something else? And what are the quality standards that have to be met, which are brand standards? If you don't meet those brand standards, you will see your hotel operator wanting to exert a lot of pressure in terms of what happens to the agreement. There'll also be a PIP, a property improvement plan, either embedded in the contract or you may negotiate that separately. And that's really the ongoing capital needs that have to be met to keep the property both up to brand standards as well as keep the building and land in shape. And so you'll see those provisions. And then sometimes there's a key money provision where your hotel manager is actually contributing to the capital expenditure spend in order to help, improve the hotel operations, where they'll essentially loan money to the hotel owner in order to get some of these capital improvements done, and then you'll pay that key money or that loan back over time. If you can go to the next slide. And move to the next slide because we've covered that. Robin, thanks. So the next thing you need to focus on is really driving revenue. And how do you drive that revenue? It's really through the guests, the food, the beverages, the sale of beverages, the events you can bring in. And so starting with the guests, that's always the main thing. As Eric mentioned, you need people in the rooms on a daily basis, as many as you can, to drive up your revenues. In our case, the LPFC case, we worked with Westin on different programs to continue attracting guests, continue to maintain existing contracts, because typically these hotels will have group contracts, whether those are with airlines or others. You're going to want to keep those contracts in place. There's typically a very heavy spend on marketing and the use of your hotel manager's reward system and reservation system to continue attracting guests. The other thing is the sale of food and beverage, and that's going to be either through the room service spend or through the restaurants, which we'll talk about a little bit later. That might be at the hotel. And one thing we had to look at in the LPFC case was just the competition between the actual hotel food service for the conference room space, for room service versus the restaurants. And they were actually competing against one another, and we had to address that during the restructuring. And then events. Events, at least in the LPFC matter that I worked on, were critical to the hotel success. That hotel really depends on a lot of weddings and conferences, and it took a lot of convincing, in particular for the weddings, to keep those contracts in place once the LPFC ended up in bankruptcy. So you're going to want to remember those contracts, especially the wedding contracts and conference contracts. Those are big money contracts, and you'll have to do a lot of one-on-one discussions to make sure those participants are comfortable continuing forward with those contracts and understand that the hotel's still in business. It's just going through a bankruptcy or restructuring process. And then that all goes to the importance of PR, which I think is pretty obvious here. You have to get good PR out into the local market to get the guests, to ultimately keep your events and attract new events. And so that should always be a key focus pre-bankruptcy, so you have a great PR plan and blast that can go out to keep the hotel stabilized and the revenue continuing to come in. And then the last thing I'll mention on driving revenue is the local government support. For the LPFC case in the Village of Lombard, the hotel is, when you can't miss it when you're driving by the Village of Lombard. It's a huge structure. It's a key driver of revenue into that community. And so we actually did get support from the Village of Lombard through a TIF district that got formed during the restructuring, through some additional monies that they were willing to contribute to the restructuring in order to help us be able to keep that hotel operating and right-size its balance sheet. And then finally, I'll mention just briefly receiverships, which we ultimately, I said I would cover, so I'll cover very briefly. Given that hotel owners sometimes own the underlying land, they may be eligible for a receivership, and so you do periodically see these hotels not in bankruptcy, but in a receivership process that can be in state court and federal court, It can be an extensive receivership that controls the whole operations. It can be more of a financial receivership, just controlling the monies in, the monies out. And that can sometimes be a cost-effective way of dealing with a need to restructure if you can implement through your restructuring through a receivership process. And I just note one bankruptcy case that came out recently from the Ninth Circuit, which I found interesting because it did involve a restructuring process, and it goes back to where we started, which is eligibility for bankruptcy. And here, the former board members of an entity that owned a business that was in receivership ultimately filed the business for bankruptcy, and the court said it was an unauthorized filing, that after the appointment of the receivership, only the receiver in that instance had the right to file for bankruptcy. So that will not be true for every receivership, but just something, again, to be aware of, to look at the order appointing the receiver and understand the underlying laws that relate to that appointment of the receiver, who may or may not be able to control whether or not a bankruptcy case is filed. And so with that, I will stop, and if there's questions, we can deal with that, or we can move to Eric.
Nancy, I do have one question for you for now. It seems pretty clear that the flag on a hotel has a whole lot to do with the value. Is there ever a situation where removing that flag or replacing that flag makes sense?
You know, it could, right? If you really have a breakdown in the ability to work with your hotel, the entity operating the hotel. So you could replace the flag. In the LPFC matter, we did look at potentially whether or not the flag could be replaced. It is a hugely expensive process because you have to keep in mind, you know, if you're taking down a Westin flag and moving, I don't know, to a Hyatt brand, everything has to be rebranded at the hotel. The rooms sometimes have to look different. Certainly the exterior and what's on the exterior is going to look different. The lobby might have to be changed. So it is a tremendous capital expenditure cost if you have to change the flag. And for the clients that we typically deal with, they can't afford that. So oftentimes you have to go make your deal with your current hotel manager to make sure they'll stay in place and keep that flag there. So it's possible, but it's an expensive proposition.
All right, thanks for that. Eric, so with that, we'll turn it over to you to take us a little bit more in depth into what's going on with hospitality defaults now.
Great. So moving ahead in the slides, we're going to dig a little bit further into hotel restructuring issues. And one issue that's important to consider at the beginning of a hotel restructuring in bankruptcy is determining whether or not your hotel is considered single asset real estate under the bankruptcy code, because that's going to have important implications for you if you're the debtor who's going to file a hotel case, and also if you're a secured lender who has a loan that's secured by a hotel that may go into bankruptcy. If we could move the slide for the presentation forward 2 slides, that would be great. So single asset real estate is, as we all know, is a defined term under the bankruptcy code under section 101, subsection 51B, which was amended by BAPSIPA in 2005 to amend the definition and also provide some additional protections for lenders with respect to single asset real estate. And actually, if you could go back 1 slide would be great. Excellent, thank you. And so why is this designation important? Well, it's important because single asset real estate debtors now are required to file a Chapter 11 plan within 90 days from the petition date, or start providing the secured lender with either monthly interest payments at the non-default interest rate or stay relief. So the timeline for a restructuring for single asset real estate cases is expedited significantly. So the question then is a hotel single asset real estate? And looking at the definition, actually 1 slide back, of single asset real estate under section 101, I've highlighted the important language, which is it's a single property or project that generates substantially all of the gross income of a debtor, on which no substantial business is being conducted by a debtor other than the business of operating the real property and activities incidental thereto. That's really the operative language under that definition, when considering whether a hotel is single asset real estate. Now, typically a hotel is a single property or project that generates substantially all of the gross income of the debtor. So that part of the definition is usually satisfied. Going back to Nancy's presentation, most hotels are owned by special purpose entities, so that entity would be the debtor, and it's not going to have any other revenue other than what's generated from the hotel operations. The key question then is there no substantial business other than the business of operating the real property and incidental activities? Well, is operating a restaurant, a bar, a spa, a gift shop at a resort hotel substantial business other than the business of operating the real property? Probably. It probably is, and therefore larger hotel resorts or full service hotels are generally not single asset real estate. The question becomes more difficult when you consider, is having just daily maid service at a roadside motel substantial business other than operating the real property and incidental activities? Well, courts have addressed this issue and have generally come down on the side of limited service and motels that just provide beds to sleep in and daily maid service and phone service are often designated single asset real estate. And then on the other end of the spectrum, larger full service hotels and resorts are generating a bunch of revenue from business operations other than just sleeping in a hotel room, and therefore are not considered single asset real estate. But the key case that really wrestles with this issue is the Iowa Hotel Investors case, a case that I was actually involved in the Northern District of Iowa in 2011. And that dealt with a Country Inn and Suites, which is kind of in between. It was a 64-room hotel that had a swimming pool, that had meeting rooms, that offered a free continental breakfast. You looked at the balance sheet and you could see that it generated 99% of its revenue just from, nightly room rental, and then 1% of revenue from other incidental gift shop purchases and meeting room rentals. And in that case, I commend the decision to you. It's not very long, but it is the one opinion that really delves into the history of the single asset real estate definition in the bankruptcy code, the purpose of it, does a survey of cases that have dealt with this issue in the hotel context, and ultimately decides that the Country Inn and Suites hotel in that case generated enough additional business outside of just running the real property that it was not single asset real estate. And that decision could actually be used to support an argument that almost any hotel is not single asset real estate and therefore should not be subject to the expedited timeline that's required for such cases under the bankruptcy code. So moving on to the next slide, another important issue to deal with at the outset of a hotel bankruptcy case is the cash collateral of the hotel. How does a secured lender perfect its interest in the cash generated from the operation of a hotel? Well, that depends, obviously, on how those cash proceeds are treated under applicable law. Are they considered rents generated from real property, similar to an office building or an apartment building? If so, that's governed by state real property law, and it's secured by a mortgage and an assignment of leases and rents that's recorded in the real property records where the hotel is located without regard to where the entity that owns the hotel was formed. Or do you look at cash proceeds from the operation of a hotel as accounts receivable? Well, if you look at it as accounts receivable, then it's governed not by state real property law, but by Article 9 of the UCC, and it's secured by filing a UCC-1 financing statement in the jurisdiction where the entity that owns the hotel is formed without regard to where the hotel is actually located. And jurisdictions are actually split over the treatment of cash proceeds from hotel operations, but the majority view is that they are accounts receivable and therefore are secured through the UCC Article 9 process. So it's important both if you're representing the hotel debtor and if you're representing the hotel secured lender to understand what jurisdiction you're in, understand how you properly perfect the security interest and the cash proceeds, and that will have a significant impact, obviously, on how a bankruptcy case involving a hotel is handled from day one. Practice tip, obviously, for secured lenders would be to take the belt and suspenders approach. Make sure it's secured through your mortgage and assignment of leases and rents that's recorded in the real property records, and also file your UCC-1 in the jurisdiction where the entity that owns the hotel was formed. Moving on now to franchise considerations. So as Nancy mentioned, most hotels are operated under a franchise agreement. So that's an agreement with a major hotel brand, like a Marriott or a Hyatt or a Hilton or a Kimpton. Recently, there's been a real proliferation of new brands in the hotel industry. And that brand affiliation really contributes significant value to a hotel. It provides the hotel owner with access to the reservation system, to customer loyalty programs that really drives what they call heads and beds, right? People coming to your hotel, filling up your hotel, increasing the occupancy, increasing the daily rate that you can charge, and ultimately increasing the RevPAR performance for that hotel. And as you might expect, the franchisor, these hotel brands, very closely guard and protect the value of the brand through various different means. Quality assurance requirements is probably the most significant. Again, Nancy touched on this. This is maintaining the quality of the hotel, making sure in many cases that the quality is uniform throughout the country. So if you go to a Marriott in Dallas, you as a Marriott hotel guest will experience the same type of room that you would have if you went to a Marriott in Hoboken, New Jersey. And the way that brands will protect that quality across the country is through periodic refreshing of FF&E, through the imposition of a property improvement plan called a PIP, which often requires significant capital expenditures. So, as a hotel owner, in order to keep that brand affiliation, you're going to have to reserve for and spend significant capital in upgrading your rooms periodically, and making sure that you're keeping up with the brand standards that's expected by most major hotel brands. Now, you might also expect that it's important for lenders to protect the value of their collateral through maintaining that relationship with the brand. And one main way that they do that is by entering into what are called comfort letters with the franchisor. Now, a comfort letter is a tri-party agreement between a hotel owner, the hotel franchisor, and the secured lender. And it typically requires an owner to provide the lender with notice of any default under the hotel owner's franchise agreement, which is a bilateral agreement just between the hotel owner and the franchisor. So if there's any default that could jeopardize the brand of the hotel, that hotel owner has to provide notice of that to the secured lender, and then the secured lender will have the right to step in and cure that default and add the cost of the cure to the loan that the borrower has to repay. And most importantly, these comfort letters require or typically provide for a franchisor agreeing to allow the lender to operate the hotel under the franchise agreement if it needs to appoint a receiver to exercise its rights and remedies under its loan agreement with the borrower, the hotel owner, or if the lender ultimately takes control of the hotel through either a foreclosure, deed in lieu of foreclosure, or a bankruptcy proceeding. Another important practice pointer for attorneys that represent CMBS lenders. CMBS debt is often used to finance hotel development in the hotels. And oftentimes in CMBS lending, the note and loan agreement are transferred among different CMBS trusts for servicing. It's critical to remember that when you are assigning the note and the loan agreements, to also assign the comfort letter with the franchisor. Otherwise, a hotel goes in distress, the franchisor wants to strip the hotel of the flag, the lender steps in to try to take control and salvage the brand relationship. If the lender didn't assign the comfort letter to the entity that is now enforcing the rights under the loan, the franchisor will not respect the rights of the lender and will not agree to allow the lender to continue operating the hotel under the franchise agreement, which could obviously result in significant harm to the lender's collateral. So always important to make sure that comfort letters are assigned together with all other loan documents when the loan is assigned to different servicers for a secured lender. Moving on to we're on the slide right now. Is a franchise agreement an executory contract? It most certainly is. There's always ongoing material obligations by both the franchisor and the owner. A franchise agreement can only be assumed and assigned with the consent of the franchisor, however. And the authority for that is under Section 365C of the Code, which prohibits assumption and assignment of an executory contract without the consent of the non-debtor party if applicable law excuses performance by the non-debtor party. While hotel franchise agreements almost always include a license to use trademarks of the hotel brand. And federal trademark law prohibits the assignment of trademarks without the consent of the licensor. Therefore, under Section 365C, it prohibits the assignment by a hotel debtor of a franchise agreement in bankruptcy without the franchisor's consent. And again, this is another important aspect of the comfort letter that the lender has. This is an agreement where the franchisor is providing its consent for the secured lender to take an assignment of the franchise agreement should it obtain control of the hotel through a bankruptcy proceeding. And so with that, I'm happy to kick it back to Judge Sigler.
All right, Eric, before we move on, I do want to go back to something that you mentioned actually in the very beginning of our webinar today. You mentioned the impact of the sharing economy, Airbnb, companies like that on some of your hotel clients. How have hotels been reacting to the introduction of the sharing economy, and what are they doing to compete?
It's a good question. They have not been reacting very well. They see it as a significant threat to the industry, and it has been a topic of discussion at all the main hotel conferences that I've been going to for the past 5 years, and there has been a lot of money invested in lobbyists to petition local governments to start imposing more strict requirements on these home sharing companies to, for example, charge them the same type of room tax that gets charged to a hotel, and regulating the environment similar to how the hotel industry is regulated, which is one way that obviously these up-and-coming home sharing companies have been able to maintain a competitive edge over your more traditional hotel. So it certainly is a high-profile issue that a lot of hotel owners and hotel industry executives are very focused on and dedicating a lot of resources to try to resolve.
All right, thanks. Jan, why don't we go ahead and talk about when restaurants fail, and then we can go back to the entire group for questions at the end.
Sounds good. First, I wanted to thank Lacey Rochester, my associate, who helped me prepare these materials, because without her help, I'm sure I wouldn't have turned them in timely. But like the other types of hospitality businesses we've been talking about, the hotels, restaurants, because they're selling not only a service but an experience, need to worry significantly about their reputation and the public's perception of the restaurant. And for that reason, I've picked out some of the topics that I've picked out to talk about are how to deal with landlords, how to deal with franchise agreements, because part of that experience is dictated by the building that the restaurant is in and dictated by the franchise, if in fact there is one there. So that's part of the reason I've chosen the topics that I've chosen to deal with. If we go through, and we're on to the next slide, so that right here is good. When you look at these cases, nope, I'm sorry, Robin, back. I'm sorry, go back one. When we look at the cases that we see, it's interesting because we still have, it seems to be, a rise in bankruptcy for restaurants. what's also interesting is that if you look through them, and as my associate pointed out, they appear to be a list of the favorite places for college kids or law school kids to go eat. And so I think it's interesting that when you look at how we deal with restaurant bankruptcies, we really have two different kinds of restaurants. And one is the high-end restaurant, and I'm going to talk a little bit about that as we go through kind of anecdotally. But I think most of the restaurant cases you're going to see are going to be ones that are in the casual dining area. And if we go to the next slide, we could talk a little bit about what we think the causes of that are. One thing that's interesting is that I think that we all are under the impression that, at least in the United States, that we've been seeing indicators that show that we really have a pretty strong economy. Yet we still are seeing a number of these kinds of cases, these kinds of facilities filing bankruptcy. And I think that might be because there's some unique problems there. One is that I think some would suspect that the recovery that we're in might not be filtering down to the folks who actually do make a good use of quick and casual restaurants or casual dining. Other issues that have been brought up is there do seem to be increasing labor costs, or at least a perception of that in the franchise area. For instance, we look at McDonald's and others who are now trying to replace employees with machines, and that might perhaps be contributing to the trouble in the casual dining area. We also see a prevalence of online delivery services like Uber Eats, Postmates, Grubhub. And what that's telling us is that the dining experience for this casual dining business may be changing, and we're going to need management to be able to respond to that so they can develop different business models that take into consideration these programs. Another factor, at least cited by the Bertucci company when it filed, is that there is a general oversupply of restaurants in the family dining and casual dining sector, and that perhaps is what's causing this increased filing. But whatever it is, we do perceive that there is an increase, and we need to talk about what the important issues are. And if we go on to the next slide, I'd like to talk a little bit about franchise agreements in restaurant bankruptcies. This is really generally not going to be an issue in your high-end bankruptcies. I've dealt with some of those. Actually, being in New Orleans, we like to say that all of our restaurants are high-end and unique, and so we don't have franchise agreements except for Ruth's Steakhouse that came out of New Orleans. But this is going to be a major issue in a franchise in a casual dining bankruptcy, is how we're going to treat that franchise agreement. Under Section 541, the franchise agreement is part of the estate. We also, under Section 362, protect the franchisee and debtor's rights by prohibiting the franchisor from taking action to terminate the franchise agreement. And assuming the franchise agreement is still there, in order to assume that franchise agreement, this restaurateur or franchisee is going to have to be able to make sure that the premises comply with the standards, catch up on the payment of royalties, deal with any damage that may have happened to the mark. Like hotels, when Eric was talking, a troubled restaurant will often find itself in trouble with its franchisor, not simply because they haven't paid their fees, but because the quality of the food or the quality of the experience has diminished during the operations. What's, I think, really important if we go to the next slide, is for those who are dealing with a troubled franchisee, whether you're the lender dealing with the troubled franchisee, or whether you're the potential debtors counsel, is to look first at how that franchise agreement is terminated. I think that we're often used to thinking that every agreement has a cure period in it, but that may not necessarily be the case. And in fact, I think we find when we look at this Applebee's case, which let's stay where we are right now, but when we look at the Applebee's case, we can see how important it is to deal with whether or not the contract is terminated pre-petition. Because if a franchise agreement is terminated pre-petition, there's nothing to assume because there's no contract. So if you're negotiating ahead of time with your franchisor and your lender, or if you're the lender negotiating, we need to make sure that when you deal with the forbearance agreement, that you build in cure periods that may not actually exist in the franchise agreement that you're in the process of trying to extend. I think a case that analyzes, and we can go to the next slide now, analyzes this issue is the Applebee's Neighborhood Grill case, or called In Re RHM. And here the parent and RHM had been negotiating on and off the issues relating to the franchise agreement for quite some time. The franchisor, or the parent, said that he alerted RMH that its agreement would be formally revoked on April 27th, which is interesting. By that time, they owed him $12.2 million. But they didn't take any action then, and didn't do anything really until May 8th. Once the court finished with that process, the court came to the conclusion, after looking, this came to the conclusion that the agreements were not properly terminated prior to the filing, and so therefore RMH had a franchise agreement that it could deal with during the course of the case. Without that, they'd have been up a creek without a paddle, or I guess cooked, since we're talking about restaurants. So the next issue, or going on to the next slide, when we get around to assuming a franchise agreement, which Eric, I think, has already covered, so I'm going to do it very briefly, is the question of whether or not you can assume the contract without the franchisor's consent to the assignment. As Eric points out, we've got this big federal issue that if your franchise agreement is covered by trademark law, then it's likely that you're going to need the consent of the franchisor. What does that tell us when we start the case? Is that if you're dealing with a Burger King or a McDonald's franchisor or any one of these smallish casual dining places, like Nancy mentioned with the hotel, the cost of rebranding one of these spots is going to be astronomical. And I mean, you're talking about taking down the golden arches, you're talking about changing the color of the roof. So quite honestly, preserving that franchise agreement for these small restaurants, casual dining restaurants, is really critical. So if you're in the process of negotiating or dealing with a failing franchisee, whether you're the lender or whether you're the debtor, you need to pay attention to what the relationship's going to be with that franchisor and see what problems are going to exist and negotiate with that franchisor, hopefully long before you end up in an actual chapter proceeding. So I'm going to move on to talk about PACA, which might not be a terribly big issue in a small case, but it can be an important issue in a restaurant that's purchasing at least $230,000 worth of produce annually. And there are restaurants, particularly ones in New Orleans, some of the high-end restaurants, that clearly do that. PACA is and I think you're going to go one more slide. PACA is really interesting. It's the Perishable Agricultural Commodities Act. And it's a federal statute, dates back to the 1930s, designed to protect folks who sold perishable agricultural commodities to mainly grocery stores but also to restaurants, recognizing in both of those instances that if you sell lettuce, it gets consumed pretty quickly in the course of operations, and therefore PACA creates a trust, basically a floating trust that floats and attaches statutorily to really all of the debtor's assets. So if you're dealing with a restaurant that has enough volume to have to deal with this, you would need to, as you go in and work on your cash collateral order and you work on your first day motions, you're going to need to make sure you decide how are you going to deal with those PACA claims. Because I assure you, there are lawyers throughout the country, their only job seems to be to go into cases and figure out where there's a PACA issue and go in and assert that floating trust. And so what you need to do is make sure that in the beginning of the case, you create a process and a procedure to deal with the PACA claims and to deal with the fact that they have this floating lien on all assets. It is interesting, PACA is, and God, if you go on to the next slide, it doesn't automatically attach to anybody who's sold goods, but you have to have certain markings on your contracts and your invoices so that you can get the protection of PACA. But most large food suppliers know how to protect their PACA rights, and you're likely to see that there. So for the larger case, PACA is an issue that you need to deal with. Your smaller cases, particularly where you have a franchisee that may have 1 or 2 stores and they don't use much produce or frozen goods, anyway, you may not have that PACA issue, but it's something to be aware of when you start out, when you start the case. And I've put in here, if we go through, if you go to I think it's slide 13, you'll see that I've cited some of the cases that deal with this in Ray Cherry Growers, Inc. The DIP sought approval of cash collateral motion with the consent of the lender, but along came the PACA claimant and argued that the PACA claims reached all of the DIP's property because of commingling. The court granted the DIP motion authorizing the use of the property, but because the court came to the conclusion that the PACA claimants were adequately protected because of the value of the property. So this case shows you that if you start off the case recognizing you're going to have a PACA problem, you can easily deal with it up front by offering in the cash collateral order the kind of adequate protection that the PACA claimants are going to need in this case. So that's something that I think you should pay attention to. And I'm going to move on to landlord-tenant issues in bankruptcy. And again, I think there's a little bit of difference between what goes on in a smaller casual dining kind of bankruptcy than what goes on in a high-end unique bankruptcy. And one of the cases that I recently did the last couple of years was I represented the folks who were acquiring a restaurant, the world-famous restaurant in the city of New Orleans down on the quarter. And in that case, it wasn't just the name of the restaurant, which, by the way, wasn't covered by a franchise, but it also was the location. The actual building was part of the brand. The outside of the building, actually the address, was part of the brand. And so when I was representing the folks who were trying to acquire that asset, I had to make sure that we were protecting the interest in both the building and our interest in the company itself. So that's, when you're starting in the beginning of the case, let's assume you're the debtor or you're the lender or you're the purchaser, whatever your role is, you need to decide in trying to acquire that property or hold on to that property or restructuring that property, where the value is. Is it in the name? Is it in which means dealing with the franchise, if there's such a franchise? Is it in the location? And then develop a plan or a course of action that protects both of those. Now, what happens is oftentimes the property is going to be leased, particularly in your smaller cases that are casual dining cases, but even in large cases, sometimes these unique restaurants, you'll find that the family, that a restaurant's been in the family for 100 years or 50, and the family, one part of the family owns the real estate, and another part of the family owns the operating business. And so despite the fact that you think of it as a family business, you may well find that you have different folks in each of those piles. And so you need to go into the case recognizing that if you need to preserve the location, how you're going to deal with that landlord. But in those cases and in the casual dining cases, we've got the issue that, again, leases are subject to assumption, assignment, or rejection. They are unexpired leases of non-residential real property, and they're deemed rejected after 120 days, but the debtor can get an additional 90 days for cause to make the decision whether to assume or reject that lease. It's, you know, this is not terribly complex decision, I suppose, if you're dealing with a single location for a franchisee or just a single location for a unique restaurant. But this can be a bit of a burden if you're dealing with a franchisee or a string of restaurants with several different locations. I think it's, you know, personally, dating back to the days before we had such limitations on the extension of the time to assume or reject leases, I think it hurts the reorganization that we're not giving the debtor the opportunity or longer opportunity to decide whether to assume or reject those leases. But that's where we are. If you're going to assume a lease, you're going to have to cure the monetary defaults, and you're going to have to give adequate assurance of future performance. So those are critical issues that need to be dealt with in when you're deciding whether to assume or reject. The other critical issue is to recognize that the assumption of those leases turns what was a pre-petition claim into a post-petition claim. And so if you're on the debtor's side, or you're a lender working with the debtor, trying to decide how to proceed towards a restructure, or if you're the unsecured creditors committee and you're worried about whether or not this restructure is going to work, it's going to be important to pay attention to which leases are assumed and make sure that the debtor doesn't untimely assume those leases. Oftentimes, the best thing that the debtor can do is drag that process out for the restructure, because at the end of the day, if the debtor makes the wrong decision and assumes a lease that they shouldn't have assumed, then you're going to end up with this administrative claim for the balance of the lease, which is a real problem unless you can manage to assign it to someone else. During the course, as we go on to the next one, which is administrative rent, during the course of the case, it's going to be necessary for the debtor to pay the rent. In fact, under Section 365D3, just to clarify, that you don't simply get the rent paid under 503, the actual necessary costs of preserving the estate, but under Section 365, the code specifically provides that for at least the first 60 days of occupancy following the bankruptcy filing, the landlord has an administrative claim for rent. What's fun is, and I think I have an opinion, but since we only say for 60 days they have an administrative claim for rent, I don't know if anyone could effectively argue that after 60 days there's no administrative claim, because I've always thought under Section 503, if you're using the space, the actual necessary costs of preserving the estate is, you have an administrative claim. But if you're representing the landlord, then it's critical that you not just simply rely on 365, but that you make sure that the debtor is in fact making those payments currently, so you're not going to end up with an argument over whether or not the lease has whether or not there's an administrative claim for the lease. So the landlord, it's important to keep track of that. And for the debtor, that's just as important to make sure you get the administrative rent paid. An interesting topic that can become more complicated the more locations you have is how to treat stub rent. which if we go to the next slide, there's some information in there about stub rents. And stub rent is a term we use to define the rent between the petition date and the first post-petition rent payment date. If the billing, the question is, do we look at the accrual date or do we look at the billing date? And the courts are actually split on this. The Third, the Sixth, and the Eighth Circuit seem to say if the rent comes due, is pre-petition, then the stub rent is not an administrative expense under 365, and they're not required to pay it timely. However, Second, Fourth, and Ninth are governed by the accrual date. And in fact, if you look at the case we cited in here, the El Paso property case, says that using the billing date really just unravels the priority scheme of the bankruptcy code. But if you're the debtor, preparing your budgets, going forward, working on your cash collateral order, you need to understand how the rent's treated in each one of those leases. Is it billing? Is it accrual? And you need to understand what circuit you're in to see how you're going to treat it going into the case. And for somebody that's got a lot of locations, this can actually prove to be a significant issue. The last topic that I thought was of real interest to the restaurateurs or labor issues. And that's mainly because everybody knows that restaurants are terrible at paying for their labor. And or at least in New Orleans, I think a lot of the Fair Labor Standards Act cases in our community arise out of bars and restaurants. So, issues that you need to deal with, if there's a Fair Labor Standards Act claim existing prior to the filing, you're going to have to deal with them. Keep in mind that they may well have a priority claim for whatever they're asserting. I think the courts are split on whether or not they can file a class claim in a bankruptcy. But whatever it is, it's going to be significant dealing with those pre-petition wage claims or pre-petition fair labor claims in a bankruptcy. And so that's an issue that you need to look at up front. No matter who you're representing in the case, you need to understand that there's a problem like that. There are states that have unions. Again, I live in Louisiana. I don't think I've ever dealt with the union issue. But certainly if you're dealing with a case in Las Vegas, California, I think you're going to run into problems about and look at how you're going to deal with that collective bargaining agreement. That is something that you clearly need to deal with or start dealing with before you file the case. Another issue that I've put in here, and I'm going to go quick because I bet I'm running out of time, is the WARN Act. And I don't know that you're going to run into a lot of cases that where you have a WARN Act issue because you've got that minimum number of employees, 100 or more. And that's not really going to be likely a problem in a small casual restaurant case, even if you have multiple locations, because I think, as we've cited here in this one case, courts have found that you may not have a single site of employment when you've got various different locations spread about. But you'd be amazed how many employees are in these large restaurants that are high-end, unique restaurants. And so it's worth asking the question, how many employees there are, just so you're aware that you could end up with a WARN problem if, in fact, you have to shut down the restaurant. So that's one of the employment issues I wanted to bring up. The final comment I have is one I'd have whether we were talking about restaurants or hotels or hospitals. And the most important thing to me is when you're getting ready to file a case, if you're the debtor, if you're the lender who's facing that, or you're the newly employed unsecured creditor committee's counsel, is you need to make sure you understand what your exit plan is. Because everything along the way in the case should be dictated by that exit plan. That exit plan may change when the debtor doesn't perform like you expected them to. when the seller backs out. But if you're not focused on your exit plan, then you can't really have a good strategy of dealing with this particular property or debtor. And I think with that, I've probably gone over my time, and I apologize. But Judge, I'm going to pass it back to you.
All right. We are, in fact, out of time. So, and I don't see any questions pending in the chat. So unless any of the panelists have a pressing comment or a question for another panelist, we will wrap up with that. All right. Well, hearing nothing, thank you very much to our panelists, and thank you to all of our viewers on the webinar for participating.
Thanks, Judge.
Thanks, everyone. Have a great day.
Thanks.